Alright, pause right here. What you're about to see may look routine, but this is where real cases quietly change direction. Preliminary hearings, waivers, legal strategy, this is the chessboard before the game even begins.
Yes, nice to meet you, Dolores. How are you?
We don't have anything. We will go on the record in the matter 25 CF 119, State of Wisconsin versus Dolores Corbine. The state appears through Assistant District Attorney Jose Vila in person. Ms. Corbine appears in person with counsel Nicholas Davis. We're set today in this matter for a preliminary hearing, but it will be a preliminary hearing waiver, correct, Mr. Davis?
That's correct, Your Honor. If you like, I can go through the colloquy I had with Ms. Corbine.
Please do.
Your Honor, Ms. Corbine is an adult female. She's a very educated female. And I explained to her that it's a probable cause hearing, preliminary hearing, and the burden's on the state. That they must show that a felony was probably committed and probably committed by her. I explained to her the burden of proof is not as if we were in a jury trial beyond a reasonable doubt. I also explained to her that this is a statutory right, not a constitutional.
This line right here matters. A preliminary hearing isn't constitutional, it's statutory. Translation, the law gives it to you, but the Constitution doesn't protect it. Once you waive it, there's no rewind button, and defense attorneys don't say this lightly.
Right, and that if Dolores should waive this today, we cannot beg and plead with you to let her have the hearing again, and she's willing to do that. Also, there is no sweetheart deal. I have not pressured her, coerced her. There's nothing waiting for her if she should waive today. So I believe that she's going to waive this hearing after speaking with her and knowingly, voluntarily, and intelligently. And I can tell you she's read the complaint thoroughly. She's asked very thorough questions. And so I believe that she is doing this intelligently, voluntarily, and knowingly. And I can tell you that she's not on any medication, drugs, or alcohol because she currently is in a treatment program.
All right, is that all correct?
Yes, that's correct.
Okay, and so you understand that once you give up the right, it is forever.
That question from the judge isn't casual, it's surgical. Courts want a clean record. No appeals later claiming, I didn't understand. This is the system locking the door, politely.
And you can't get it back?
I do.
Do you have any questions before you fully waive your right to a preliminary hearing?
Not at this time.
All right, then the court will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. The court will find probable cause and bind the matter over. Information, Mr. Vila.
Your Honor, I'm filing the information currently. It will mirror the criminal complaint.
And if it mirrors the criminal complaint, I'll advise my client, because she would like to go forward, and we would waive any further reading, and with your permission, she'd enter not guilty on all counts.
All right, not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Status, Mr. Davis?
Judge, when can you, in the new year, what are you looking in February? Or what month are you looking at, Judge?
Maybe January or February if we're just looking for a status.
Few appointments in the month of January and February.
When
Can I just go look at my phone real quick?
are
What do
they?
you have going on?
I have a couple appointments. OB appointments. I had just got them scheduled. I don't know the days right now.
Are they mid-February, early February?
I want to say one is February 19th, but another one is January. If I had my phone, I could look
All
real
right,
quick.
go get your phone.
Okay. The appointments would be January 14th and February 9th.
January 21st at 10:15 or 2:30, Mr. Davis.
I'm in trial that date.
January 22nd at 9:30.
I'm in trial on that date.
January 23rd at 9:45.
If it can be by Zoom, I can make it happen.
Zoom's great.
Thank you.
Could I appear by Zoom too?
Yes.
Okay.
But I'm going to tell you right now, if your Zoom doesn't work, if it's sketchy, if it cuts in and out, if you're not able to log in, that's on you. That means you failed to come to court. That means a warrant.
Okay, I will.
And here's the modern courtroom twist. Zoom court sounds convenient until the judge makes it crystal clear. Bad Wi-Fi doesn't excuse a missed court date. Technical issues can still land you a warrant.
Keep that in mind.
All right, thank you. We are adjourned.
Thank you, Your Honor.
Thank you.
Mr. Jones.
Thank you. Thank you very much, Dolores.
We will go on the record in the matter 25 CM 229, State of Wisconsin versus Robert Jones. The state appears through Assistant District Attorney Jose Vila in person. Mr. Jones appears in person without counsel. We're set today for an initial appearance. An offer was presented. Are you accepting the offer?
No,
You want to go to trial with this?
of course. Yes. Yep.
Would you like to have a court trial? Have me decide this?
It doesn't matter. I mean, as soon as the facts are presented,
That's right. This is that truck and that issue.
yeah, I
All
was,
right. So, Mr. Jones, do you understand you would have the right to have a jury trial, or you could say, you know what, I want to argue to the judge and have the judge decide? That's your right. Do you understand that?
yeah, would I be able to have like the police officer that was there in court too and stuff? So,
For me, yes.
okay,
To
yeah,
testify.
definitely. I would do the judge trial then.
But I mean, you would still need to figure out how to subpoena him and do those kinds of things though too. But that's with anything, but yes, they would be able to testify, and you would need to provide your witness list, and the state would provide their witness list, and you'd be able to determine who they are calling to testify, and that may mean that you don't have to subpoena them. Okay?
I just, yeah, okay, I get it all, but
Yeah.
Your Honor, just to clarify the record, the offer for the citation was made at the previous hearing we had, and the follow-up offer was made since that new diversion program at the DA's office took place, that if he just did a class, we'd dismiss this altogether. He also declined that. I just want to make the record clear.
This is where emotion collides with strategy. The state offered diversion classes, dismissal, clean exit. He said no. Why? Because for some people, it's not about convenience. It's about clearing their name.
can I speak? I just,
I know your side. I know.
no, I understand that, but just because he probably doesn't, but I mean, I'm 13 miles away and there's a pipe in someone else's truck and the cop takes it out of their truck and says, I'm charging you with this.
I understand where you're coming
So I
from with
just-
that. So
Okay, okay.
you said it at the last hearing.
I know.
You think we could get this done in half a day, Mr. Vila?
Yes, Your Honor, if not less.
And this is your case?
Yes, Your Honor.
I mean,
Yeah, I don't think we would even, how many witnesses do you think you would have?
2.
How many witnesses would you have?
just my mom that saw him take the pipe out of someone else's truck and say it's mine.
Your mom?
My mother.
The law enforcement officer probably, or they're probably gonna call him.
Well, it's don't they have to prove that?
They have to prove beyond a reasonable doubt, yes.
Okay, well, then I don't need any witnesses really.
Okay, so,
I mean, can I just say one thing though? I mean, I'll be 60 years old on Wednesday. I've never been in trouble for drugs, misdemeanor, criminal, nothing on my whole record. And they want me to,
I understand, and you can make those statements.
Okay,
and those
gotcha. I'm
arguments,
sorry.
But right now, let's just try
Okay.
and get this scheduled.
yes, ma'am.
How about January 22nd at 9:30? And I would think 2 hours would be sufficient. Or the rest of the morning. Let's just do the rest of the morning. January 22nd from 9:30 till noon, okay?
Sure.
All right, so anything else?
No, for me.
Does the
Alright.
court want to put any kind of scheduling order for Mr. Jones to follow on this?
Mary will get one mailed and get it out.
Fair enough. Thank you.
What's that?
You'll get, my assistant's gonna do something called the scheduling order. It says when the trial is, and it says, when your witness lists are due
Okay,
and
great,
those
great.
kinds of things.
Okay.
So you should expect that in the mail next week or so,
Okay.
okay?
Can I ask one other question?
Yes,
I mean, what's the maximum penalty on this?
30 days.
Okay, perfect. Great.
Yeah, it's a $500 fine, 30 days.
Yeah, and it's drugs on my record that I don't even do drugs. So it's like,
Again, I understand where
I'm
you're coming
just saying
from.
though,
You're
otherwise I
against it.
would have just took the citation and just been done with it. But it means a lot to me, not been in trouble my whole life. So I'm not gonna start now.
I appreciate that. Okay, so we'll see you on the 22nd.
And that's the quiet power of the courtroom. No shouting, no drama music, just everyday people making decisions that follow them for life. This isn't TV. This is real.
Okay,
Yep, I'll
Thank
be
you.
here. Thank you.
Ms. Sangate? You can come get your notice if you want it, sir.
Sure, I had to call. I almost didn't get through.
We will go on the record in the matter 25 CF 169, 25 CM 210, State of Wisconsin versus Veronica Sangate. The state appears through Assistant District Attorney Jose Vila in person. Ms. Sangate appears in person without counsel. We're set here today in these matters for initial appearances. Ms. Sangate, have you applied for a public defender?
Yes, I have.
And do you qualify?
I do. And then I kind of told him that I was Mr. Davis. I was here. He
You
was,
hired him?
I was
But then
going
you
to,
couldn't pay his retainer, and then you went to Door Drill or something, and they wrote
Yeah.
a letter, and they said if the court would appoint, if you qualify for public defender, the court cannot appoint an attorney. I will if you want to pay $2,000 down.
I don't have that.
Okay, so then you have to reapply for a public defender.
Okay,
Okay, and let them know that you want a public defender again, because the court here, so you can understand why the court would need a lot of money down, because
okay,
a court-appointed attorney means the county has to front it. The county has to pay for it, and if you qualify for a public defender, they're not going to put, or I'm not going to put that burden on the county to pay for your representation.
Right.
Again, if you want to put money down, you will get the money back if it's not used. And having an attorney, a court appointed, are the same private bar attorneys, even Mr. Davis. But, that means that, you just have to have money down to make sure that the county is not the one paying the bill.
okay.
Okay?
Yeah.
So reapply for the public defender, so you can get an attorney appointed to you. These are felony cases, and so would you like to proceed with your initial appearances here today, or do you want a little bit more time to reapply?
Can I reapply, please?
Yes.
Yes.
I'm going to schedule you for December 17th. That's next Wednesday. So when you're done here today, make sure you call the public defender and get them back on board. You had one appointed to you, so hopefully they can get that person reappointed and we can get the matter moving, okay?
Okay.
All right, thank you.
Yep.
We are adjourned.